Hi, welcome to the show. You're watching Your Future, Your Finances. I'm your host, Brian Kuhn. Excited to be here today with our guests. I'm speaking with Eleanor Hunt, who is an estate planning attorney and senior counsel at her firm. Estate planning is a very important topic on this show. We have guests talking about how to map out the rest of your life and make sure your estate is in order. It's a very important topic. So, Eleanor, welcome to the show.
Thank you for having me, Brian.
Sure. So tell us a little bit about yourself, your background.
Sure. My name is Eleanor Hunt. I'm an attorney at the law firm of Joseph Greenwald and Lake. I practice trusts and estates, which includes drafting wills, trusts, power of attorneys, and advanced medical directives. I also practice family law, which includes divorce matters, custody, child support, alimony, and adoption. I also have a background in real estate law. I'm licensed to practice in the state of Maryland as well as the District of Columbia.
That's great. So if somebody shows up at the office, what's the normal process and the documents that they create as they meet with you?
At a minimum, the basic estate plan should include 3 documents, those being a will, a financial power of attorney, and an advanced medical directive. And I'll go through each of those very briefly to describe what they are. With regards to the will, a will is a written document that controls the disposition of your assets upon your death. Within the will, you can designate a personal representative. That is the individual that will handle the administration of your estate. They will file your will with the probate court. They will take possession of your assets, notify the interested persons, the creditors, file certain documents like an inventory, an information report, make sure that creditors are paid, and then distribute your assets in accordance with your will. Within the will, you also have the ability to appoint a guardian for your minor children if you have minor children. So that is a very important document for those purposes. The next document that is included in the typical estate plan is a financial power of attorney. And that is a written document wherein you would appoint an agent or an attorney, in fact, to make certain decisions on your behalf regarding financial and non-financial matters. For instance, you're giving an agent the right to make decisions regarding your real property. They can go out and obtain a mortgage on your property on your behalf. They can sell your property. They can open a bank account on your behalf, withdraw funds from that bank account. They could even go so far as to change the beneficiaries in your retirement plans. So this general power of attorney provides broad and far-reaching powers to the agent. So you should be very careful when you designate your agent so that you feel comfortable with this person.
Yeah, they have a lot of responsibility.
Absolutely. The financial power of attorney may take effect immediately. And in that case, you need to be really careful with who the agent is because they'll have the powers that you delegate to them immediately, or the financial power of attorney can spring into effect upon the occurrence of certain circumstances. For instance, upon your incapacity or disability as certified by your physician or by your then treating physician. So that is a possibility as well. In your financial power of attorney, you can also nominate a guardian on your behalf so that if you become disabled or incapacitated, this person can make decisions regarding your person as well as your property. And the third estate planning document that's typically included in an estate plan is an advanced medical directive. And in that document, you have the ability to appoint an agent to make health care decisions on your behalf. And that agent will make those decisions when you are unable to do so. Within the advanced medical directive, you also have the ability to make decisions regarding whether or not you want to have withheld or withdrawn certain life-sustaining procedures if you are in one of 3 conditions as determined by your physician. If you're in a terminal condition, an end-stage condition, or a persistent vegetative state, you can make certain decisions within the advanced medical directive regarding what types of treatment that you would like to receive. Within that document, you can also confirm whether or not you want to donate your organs or tissues or eyes. You can also provide specific instruction regarding funeral arrangements and your burial. So it is a document that is very advantageous, and all 3 of these are, as far as providing instruction regarding what you would like to happen upon your death, or upon your incapacity or disability.
It seems like they're very important documents, but my understanding is that not very many people actually go out and get these. Why do you think people avoid
It's
doing
unfortunate that a lot of people don't go out and do these. And we just saw with the passing of Prince that it's not only common in the general public, but also with high-profile individuals that are making a lot of money. There are various reasons that people don't move forward with this process. Some feel still in certain cultures that it's taboo to talk about death, that if you talk about it, it's bad luck. It'll hasten the process if you talk about it, and it's unfortunate. A lot of people are also misinformed about a will and what protection it can provide. They think, oh, well, there is law in Maryland, for instance, that covers that, and my spouse and my children are guaranteed to get my property. But that's not always the case, and as I explained, there are other aspects that are covered in a will that you would prefer to have the ability to delegate to a specific person as opposed to the state law coming into play and taking effect.
Could they just write down their wishes on a piece of paper?
They could, and we had talked before about the advanced medical directive and the financial power of attorney. If you write it down yourself, there are certain requirements under the Maryland law that these documents have to comply with. And that's why it's important to have an attorney, because if you're going to take the time to write it down and you're showing that it's important to you, you really do want it to be honored, and it may not be honored if you do it yourself. For instance, with the power of attorney, there is Maryland law that's very specific and provides requirements as far as it being in writing, as far as it being witnessed and notarized, and those need to be followed. There are also certain enforcement provisions for the power of attorney as long as it complies with a statutory form or is substantially similar to that statutory form, then you receive the benefit of certain enforcement provisions. For instance, if you take your power of attorney to a third party like a bank and it complies with the Maryland formalities and the Maryland law, and that third party decides they don't want to honor it, you can enforce that document through the court and recoup your attorney's fees that you incur.
And that's very interesting. We've got to take a break. We'll be right back. We'll continue on that topic. We'll be right back. You're watching Your Future, Your Finances.